Good morning. This is Dawn Moore with Allegiance Title Company, and as you might guess, this is my first Facebook Live experiment. So I'm excited to be here with you today, but for some of you, you may not know that about 6 months ago, my daughter, Blair Raggio, joined Allegiance Title Company. So she is helping me with this Facebook Live presentation, and I'm thrilled to have her on the team, and we are thrilled to share this conversation with you today. I want you to know that we are here right now live at the Slate Studio here in Dallas. For those of you who don't know the Slate Studio, it's a new Dallas co-working space for small business owners, and it's in the Design District. They were kind enough today to allow us to use their studio because Allegiance Title is an essential business, so our offices are fully operating today. Thank you, Slate Studios. We appreciate your generosity, and we're thrilled to be able to support another small female-owned business. So today, let's begin. I have been asked repeatedly to discuss the COVID-19 addendum. I'm going to tell you what I have learned. I'm not an expert on it, but I have learned a great deal. And Blair is going to help me with the questions that you might submit on Facebook Live. If you would please hold some of your questions toward the end, that would help us keep track of all your questions. But if you'll let me begin, I want to talk about it. Obviously, the COVID-19 outbreak and its impact on our industry has encouraged lots of discussion about what happens when someone cannot meet his or her obligations under the contract because of COVID-19. The big question is what happens when a closing date is missed that would not otherwise be missed but for the onslaught of COVID-19. A few weeks ago in the news suggested the need for a coronavirus clause. In the legal world, it is known as force majeure. This is a concept in law that excuses a party from not performing its contractual obligations that becomes impossible or impracticable due to an event or effect that the parties could not have anticipated or controlled. The problem is there is no force majeure clause in our TREC promulgated contracts except under paragraph 14 dealing with casualty losses. Under paragraph 14, it simply states that if there is a casualty loss and the seller cannot restore the property due to factors beyond seller's control, buyers are given some options, none of the options to hold the seller in default. Basically, the force majeure or event beyond seller's control excuses the seller's performance. In the absence of a force majeure clause addressing the issues we're facing with COVID-19, we now are left with the common law contract doctrines of impracticability and frustration of purpose, which rarely results in excuse of performance. Texas courts have generally recognized the purpose of force majeure to excuse the party's performance only when caused by circumstances beyond the reasonable control of the party or by an event which is unforeseeable at the time the parties entered into the contract. And just because the event makes it more difficult or economically more burdensome than a party had originally anticipated, that is not a reason to excuse them from performance under the contract. Further, the courts hold that before a party can assert a force majeure excuse, they must have made every reasonable effort to overcome the obstacle. Instead of relying on the common law, then, the Texas Realtors provided you now with a COVID-19 addendum. It specifies events that would constitute a force majeure and what the ramifications are of missing deadlines in the contract due to one or more of those events. When the force majeure events and ramifications are defined in the contract, Texas courts hold strictly to those. The contract then dictates the application, effect, and scope of the force majeure. Therefore, it is imperative that buyers and sellers consult an attorney before signing the addendum. The addendum is not mandatory. Now, I have seen two other addenda versions out there, and when comparing all three of the addenda, my choice is the Texas Realtors addendum. None of the addenda are perfect, and all are subject to misinterpretation and conflict. For example, one of the other addenda defines what would constitute an event of force majeure in its first paragraph, then provides for a negotiated number of days for the extension. But then in the second paragraph, it defines another event that I believe could be included in the first paragraph. However, the delay set forth in the second paragraph is different than the negotiated delay in paragraph 1. Clearly, there could be a conflict between these dates. Further, there are no time periods in that particular addendum specified for giving notice of any delay. It simply states that the delayed party shall give notice to the other party within a reasonable time. That particular addendum additionally adds, notwithstanding anything to the contrary herein above, either party may terminate the contract by sending written notice to the other party if the closing cannot occur within negotiated number of days, or blank days, from the closing date as set forth in the contract, and the earnest money shall be released to the buyer. That paragraph seems to imply it does away with any enforceability of the buyer approval or property approval provisions under the third-party financing addendum. I think that could cause a conflict. The other addenda that I reviewed defines one event of force majeure as inability of a vendor, agent, lender, title insurer, attorney, insurance company, utility, or governmental agency whose cooperation is required to perform a necessary service. It is implied in that addendum that that has to be related to a COVID-19 emergency issue, but it's really not clear. What if the lender or title company just puts this contract on the back burner because they know it has an automatic 30-day extension, and then blames their inability on the backlogged orders that we now have? Normally, this would not constitute a force majeure, but this particular addendum allows it. This addendum that I'm talking about now does require certain notices within specified times. For example, notice of delay must be on or before the deadline being delayed. Courts will hold strictly to those deadlines. If the delayed party misses the date of notice, then the force majeure defined in that contract does not excuse the delayed party from performance. And since the contract defines the event and scope of force majeure, the delayed party cannot use common law of impracticability for excuse of performance. Now, I want to talk about the Texas Realtors Covid-19 addendum, because this particular addendum does not contain those same issues. But under the Covid-19 Texas Realtors addendum, it does define a force majeure as a voluntary or mandatory COVID-19 quarantine, among some other very specific things. But my concern is if the quarantine, voluntarily or mandatory, delays the closing by 1 day, according to this addendum, the closing is automatically extended 30 days. What if the quarantine that causes the delay is shorter than the 30 days? The extension is an automatic 30 days under this COVID-19 addendum. Can you see some issues that might arise due to a voluntary quarantine by any person, including the buyer and or seller? Many people have voluntarily quarantined themselves. Would they be able to excuse themselves from performance of this contract by doing so? And then, what does this do to any domino closings? Do you need every subsequent dependent contract to have the same addendum? What if the subsequent contract is not impacted by what is defined under that addendum as a force majeure? It would not automatically be extended. So the addendum goes on to provide that if any portion of the closing still cannot be performed by the extension, so after those 30 days, if it still cannot be performed, either party may terminate the contract and buyer will receive a refund of the earnest money. It's not really clear if this particular delay after the extension also has to be related to a COVID-19 issue. Can we still terminate for any issue? Although the addendum requires the parties to use their best efforts to utilize remote services to perform obligations under the contract when they are under quarantine, unfortunately, as we all have discovered, even though Texas has passed the law that we can use remote online notary services, the lenders have not yet adopted the program. And so 95% of our closings are having to be closed in person. The Texas Realtors Covid-19 addendum very specifically states that even though the buyer may have removed their financing contingency, if buyer is not able to fund their loan and close due to buyer's loss of income from COVID-19 related issues, then either party may terminate the contract and the earnest money will be refunded to buyer. Basically, this extends buyer approval under the third-party financing addendum all the way to closing and extended closing if need be. If buyer loses their job or their salary is reduced such that they can no longer qualify for the loan under buyer approval, they can terminate the contract and receive reimbursement of their earnest money. One of the issues with the Texas Realtor COVID-19 addendum I see is there is no time frame for notices. I think it should require that the delaying party provide notice of the delay at least on or before the original deadline. And then, if the contract is extended, to provide notice of termination within 2 days if it still cannot close in 30. It is very difficult to draft a force majeure addendum to cover every issue, as you can see. But understanding that common law only excuses performance under a force majeure event if the event is out of the control of the party seeking to be excused from performance and the event is unforeseen, we now need to consider that any contracts drafted during this time can foresee the challenges that the COVID-19 emergency has created and therefore should address it in the contract, otherwise cannot rely on common law. So, again, back to the Texas Realtor COVID-19, which of the three that I have seen is the best. I do recommend that if you are entering into any contracts during this time, this addendum be submitted to your buyer and seller, and that you strongly encourage them to consult their attorney before signing. Whether you use the Texas Realtors COVID-19 addendum or other such addenda floating out there, or one of the clients you're working with has an attorney that will draft one, here are some of my tips. First, review the force majeure events, remedies, and requirements very carefully. 2, identify the notice requirements and deadlines that have been or may be triggers. Failure to abide by the notice requirements could preclude a party from applying the force majeure clause. 3, before deciding to invoke the force majeure clause, the party should assess alternative means for performance. They must make reasonable effort to perform, and there may be other ways. Just because it's difficult or economically more burdensome is not an excuse. 4, identify the collateral effects of the addendum. What does the addendum do to the domino contracts? 5, encourage the parties to communicate as early in the process as possible. The sooner the communication, the greater likelihood of resolution. And 6, retain all supporting documentation. Needless to say, I've received many questions about this concept of force majeure. The very first question I got, though, had to do with a seller who was relocating. So he put his house on the market, and then he got it under contract. Before closing, he lost his job due to COVID-19. The question was, is that an event that would excuse the seller from the obligations to sell the house? My answer to that, without a specific provision in the contract to allow the seller to terminate, my answer would be no. Common law would not see this event as making it impossible or, frankly, unforeseeable, and therefore the seller will still be obligated to sell the home. The seller will just have to find another house. But think about it. If the seller was excused from performance, then what happens to the buyer? Then the buyer has to find another house. And unfortunately, losing a job, whether it be related to COVID-19 or anything else, is not an unforeseeable event. The next question, the buyer's salary was reduced by 15%. He can still qualify for the loan, but he is anxious now, the COVID-19, and he wants to terminate the contract. Can the buyer terminate? I have repeated this often. Fear is not a contingency under the contract. And in this particular instance, this reduction in salary did not make it impossible for the buyer to qualify under the loan. Therefore, buyer does not have the right to terminate the contract. Force majeure has been an often litigated term, and after this season passes, I believe we will see more issues litigated under the concept of force majeure. My hope is that sellers and buyers, realizing that we are in uncharted waters, will work amicably toward resolutions for the benefit of all parties. Now, Blair will read the questions you've posed, and I am going to, hopefully, answer at the best I can. So Blair, do we have some questions?
Please start sending your questions via Facebook Live, but in the meantime, Dawn, Mom, whatever we want to call you, will you tell us what some examples may be when it's difficult versus impossible with COVID-19 and what you've heard recently?
Just recently, we had a situation where one of the spouses was in the hospital for cancer treatment. And the papers could not be delivered to her, nor could we do a power of attorney to her. So we thought, well, let's give her a power of because they would not let anybody in the hospital, let me clarify that. So then we offered to send a power of attorney to the hospital and ask that some hospital administrator, because many hospitals have notaries available, to notarize the power of attorney, giving her husband power of attorney to sign the documents for closing. Unfortunately, the hospital said they were not authorized to sign any power of attorney that was not health related. So they could not notarize this document for us. With that, not being able to get a mobile notary into her office, this transaction could not be closed by remote online notary. We have an impossible situation that I don't believe could have been foreseen. Having said that right now that we know of these issues, could we foresee possibilities with people that are having these medical issues in the midst of this coronavirus emergency? Should we consider getting powers of attorney ahead of time, just in case? That might be a foreseeable event.
Another question for you. How long will the addendum be in place?
That's an interesting question, and I don't know that any of us can answer. Will this type of addendum be something that will be part of the contract in the future, because, as we said, common law only protects when the event is out of the party's control and unforeseeable. Now that we have had a pandemic, is a pandemic foreseeable in the near future? And will this be part of our practice for the future? I don't have an answer to that. We will see.
What are other options to exercise instead of the COVID-19 addendum in lieu of everything happening right now?
Good question, but there's really my hope, as I ended in my little presentation there. My hope is that the sellers and the buyers will work together by communication, often and frequently, about any delayed processes, and that we all come together and not use this time to just try and delay performance, but that we all use our reasonable efforts to perform and understand that anything that a buyer does affects the seller and his future transactions, and vice versa. The seller affects the buyer and their transactions. So again, it's more amendment to contract and the parties working through it. I know that is not always easy, but hopefully during these times the people will work together.
This may be in addition to your answer just then, but what if the contract was signed prior to the addendum coming out and the parties now won't sign the addendum? What do you do?
Unfortunately, the parties don't have to sign the addendum right now, and that reminds me of a question that came up the other day. A buyer wanted to terminate the contract based on a force majeure event that was defined in the addendum, but the addendum never got signed. Without the addendum having been signed, they can only rely on the common law concept of force majeure. And unless the courts could hold that when they originally signed that contract, they could have foreseen this pandemic and the issues it causes, then the common law would excuse them from performance unless the courts say it's foreseeable. And that's why I say during this particular time, any contracts now entered into should consider adding the addendum.
What are offices doing now for closing? What is common practice to keep us safe and our clients safe?
I have brought this up in a video before, and I just want to, one, say I am not a doctor, and none of us have the answers. But in an effort to continue our essential business, closing these transactions, we first seek to close them remotely using the remote online notary. And as you heard me say briefly, the lenders have not yet adopted that. This will be a change in practice in the future because they will have to start adopting this. But right now they haven't. So my notaries have to put themselves in the physical presence of the client to take their acknowledgement and look at their IDs. Unfortunately, then my people are also frontline people. So what we have suggested now, in an effort to try and keep our social distancing and keep our offices clean, we have wiped down our offices very clearly. We are sending papers ahead of time to the buyers and sellers for them to review and do a closing over the phone. They can sign what papers don't require notarization, bring those with them to our offices, and we will do curbside notarization. The notary will come outside, the client will roll down their window, we will take their acknowledgement, they will sign the necessary documents in front of that notary, they will hand us their driver's license or their passport so we can verify the ID, and then we will take their acknowledgements and sign the papers. That is a way that we can keep distance to protect the client and to protect our frontline people.
Going back to the contract, what happens if a buyer cannot go to the property to view repairs at the property?
That was a good question that I received the other day. The seller will not allow the buyer to do a walkthrough of the house before closing. This is a situation where they're concerned about bringing any coronavirus virus into their home. So the seller's refusing to allow the buyer to do a walkthrough. I would suggest that to delay the closing, probably that is not an excuse to delay the closing. There are other ways a buyer could inspect that repairs were done. The seller could walk through the house, take a video through the house, they could FaceTime, they could show every area that needed repair. The seller can provide repair receipts, and potentially the buyer could talk to any of the repairmen that did the work. And I think the buyer then would have to make a reasonable effort to close, and that would not excuse his performance.
We've got a few more questions. I'm looking at some of our other pages now. Someone asked if you would do 5 or so key points to analyze the use of the form stated at the end of your talk prior to the Q&A. Now this is coming a little bit in the middle of the Q&A, but are there any 5 points that you would look at specifically other than what you had stated? Maybe we can re-summarize those to what you would look at as you're entering into contracts at this time.
I think, as I said, I did give you 5, actually 6 steps. If you're going to use an addendum, which I do recommend, that you be sure your clients, obviously it's your clients that need to take the responsibility for this, but you need to make sure that they review the force majeure events, remedies, and requirements very carefully. I'm reiterating what I said before, but hopefully you can take notes on this. You need to identify the notice requirements and deadlines that have been or may be triggers for any extensions, because failure to abide by the notice requirements could preclude a party from applying the force majeure. Before deciding to invoke the force majeure clause, the parties should assess alternative means for performance. Reasonable effort is required. Being economically more difficult or burdensome is not an excuse for performance. You need to identify any collateral effects that your addendum may create. For instance, you've got some domino closings that may not be able to happen because a force majeure happens on this particular property, but not the domino contract. Encourage your parties to communicate. I keep going back to this. I think if the parties keep communication open and clearly do this early on in the process, there's a greater likelihood that they will come up with resolutions without invoking the force majeure. And finally, to invoke a force majeure clause, you must retain all your supporting documentation.
All right, we've got a question from an agent. It says, a commercial client of mine received notice from her tenant that he had to lay off his employees, and this was a force majeure situation. There's no force majeure clause in our lease, but she was asking me what to do. We did have him sign a guarantor form for his company when he signed the lease. Not sure how to advise her.
This is a similar question also in residential but commercial, and we're hearing a lot of commercial tenants asking to break their leases. This is not a force majeure clause that excuses their performance under the lease. However, you know that you've heard that part of the disaster recovery rules in Dallas County, they will not allow any evictions before May 19th. So there's basically a stay. The Texas Supreme Court held off evictions till April 18th, Dallas County May 19th, and Tarrant County has an indefinite date for allowing them. These will have to be heard in court for these eviction proceedings, and the court will be, once May 19th rolls around, the court will be looking at some of these things. But without more, and with these leases, that tenant is still obligated under that lease. They just cannot be evicted for the next 2 months. Having said that, does not release them of the obligation of the rent. So it's a consideration that we may have some backlog in the eviction courts, but again, the tenants and landlords, I'm hoping, will be able to work something out and maybe come to mediated terms.
Now, Dawn, we have quite a few viewers today, which is awesome. Many of them are probably subscribed to your weekly tips. Will you continue to provide weekly updates on COVID-19 and the contract and addendum with your weekly tips coming up in the next few months?
I will do my best. And thank you. I always seek your input on what you would like me to talk about in the videos. So I will do my best. If you have a suggestion or you have a particular issue you want me to talk about in a video that will be coming up on a weekly basis, please email it to tipoftheweek@allegiancetitle.com. Remember, I try to keep my videos 2 to 5 minutes long, so sometimes I can't cover everything in one video. But please send me your suggestions and I will do my best to update you.
From another agent, do buyers and or sellers have to sign the addendum?
No, the addendum is not mandatory. So neither the buyer nor the seller has to sign the addendum. If you do not sign the addendum, there is not another force majeure clause in our promulgated contracts other than under casualty laws, as I talked about. With that, then, the only protection for excuse of performance is common law. And here is my issue. Yes, this pandemic is out of the control of either the seller or the buyer. But at this point, this pandemic is not unforeseeable. So common law may not be available for the parties to use to excuse any performance under the contract.
Let's see where we are. As a listing agent, is there any additional disclosures we need to provide to showing agents or the sellers to protect us in regards to the spread of COVID-19?
This is an interesting request I get often, and I have to refer you to your associations because they're providing you some good information, just like the Texas Realtors provided this COVID-19 addendum. They're giving you advice as to the safety and the ability to show properties during this time. You must be empathetic to your concerns of your clients, as I know we all are, but some are more concerned about this than others. And to avoid any issues, please refer to your association on guidelines for that.
Have you heard that it is being advised the SDN disclose if someone is diagnosed with COVID-19?
I have not heard that, but wouldn't be surprised if that might be something that comes up. But we all must be very careful. There have been some people who have sent out forms asking before people come to closing or before they come to see a house, has anyone been infected in their house? Has anyone traveled from out of the country and come to their home? Has anyone been sick recently? We cross the line of some privacy issues and health issues that we need to stay very careful not to cross that line. So asking somebody about being infected with a coronavirus addendum, I'm not sure how the Texas Real Estate Commission or the legislature will handle that in a future seller's disclosure notice.
Bouncing off of that, which this may go beyond our real estate knowledge, but does this not violate HIPAA and privacy laws?
Thank you. That's what I was talking about. I don't know. Again, it goes beyond my expertise, but asking about health issues could violate that.
On this topic, can sellers and or buyers sue if they have showings and someone has COVID?
Wow. I don't know. Can I just say I don't know if there's any liability if we open our home for a showing and someone comes with the coronavirus. I don't know what's going to come about. Many people, as you know, don't know that they have it. They're walking around without any symptoms. So there's really no case law on this yet to find out. This will be an interesting time after we pass through this season.
Dawn, I think we're kind of summed up on our questions today. If anyone has any last minute questions, send them. But I just wanted to hit a few points before we sign off today. I'm Blair Raggio. I'm Dawn's daughter, if y'all didn't catch the first part of the video, and I'm now working with her. And so I'm here to be her biggest fan and tell y'all a little bit of points that we need to hit before we close out today. First, everyone that isn't subscribed to Dawn's weekly podcast, please text TITLE, T-I-T-L-E, to 313131. And we encourage you to visit our website, as Allegiance Title is currently open and fully operating in all of our locations. You can see our branches' websites through our website and see what's going on. And also, we are offering curbside closings to protect your clients, to protect our colleagues as we go forth in the next few weeks. We've gotten some more questions, but I just want to reiterate that Allegiance Title is open and operating for business, so come see us. We'd love to see y'all. Let's hit the last few questions before we sign out.
All right.
Is there any provision for a tenant who's leasing in Dallas but has been caught in another state where they are caught in shelter in place and cannot return?
The only provision that would protect the tenant who is caught out of state and can't return to their unit is simply that they won't be evicted for failure to pay rent for at least 2 months in Dallas County, and maybe longer. They may extend that. But the tenant still has to pay the rent.
Buyer's agent email. The addendum asking if sellers would sign. The contract is subject to sale of other property by buyers. I would think seller could extend the time for loan approval. The addendum is not in seller's best interest to sign. What do you recommend?
That's a difficult one, and again, I'm asking the parties to discuss and try and work amicable resolutions that work for both parties. But we've got a contract that has sale of other property contingency on it. The sale of other property contingency is a situation where the buyer says, I need my proceeds from the sale of my house to buy this one. And if I don't receive those proceeds, I don't have to buy this house and I can be released. If the other contract that the buyer has is subject to this COVID-19 addendum, that may be impacted, and then the buyer will not have his contingency satisfied on the purchase of his house. And under that addendum, unless the buyer and seller extend that date, it's an automatic termination of the contract if the buyer does not receive their proceeds on or before that date.
Seller was all cash buyer. The funds for this property were coming from his closing of a large commercial property, which was terminated. Does he lose his earnest money? This closing was scheduled for March 18th.
In my opinion, without a contract provision that would specifically address a situation where the buyer no longer has the funds available to close because of COVID-19, I don't know how you would write that. But unless the contract has that in there, then no, I do not believe that excuses the buyer's performance, and they are in default. They wrote an all-cash contract expecting funds somewhere else. Those funds not coming from somewhere else, I would argue, is not an unforeseen circumstance, whether we have the COVID-19 or not. So under common law, I do not think they're protected based on that scenario.
All right, Dawn, I think it's time for us to wrap up, but we'll remind y'all that the full video is recorded. So if you missed a portion or you'd like to share it with anyone, go to our Facebook page, Allegiance Title, and go to the post or videos, and you can share it or view it again.
Thank you all for coming. We look forward to seeing you soon in person.